You know that old saying, a person's home is their castle, right? It's supposed to be our ultimate place of privacy, our sanctuary. But what happens when that castle becomes a crime scene? Well, today we are getting into a huge Supreme Court of Canada case that literally redrew the line between our right to privacy at home and the power police have to keep everyone safe after an arrest.
All right, so let's get right into it. The conflict here is really intense. On one hand, your home has the highest expectation of privacy that our laws recognize. But on the other hand, you've got police officers in a potentially dangerous, fast-moving situation who need to protect themselves and everyone else. So where do you draw the line? This explainer is going to walk you through exactly how Canada's top court tried to answer that very question.
So this whole story doesn't start in a courtroom. It starts with a frantic 911 call. And it's a situation that just escalates so fast, it ends up creating a whole new legal standard for the entire country. We're talking about the case of R.V. Stairs.
And man, things unfold in a flash. A witness calls 911 saying they saw a man hitting a woman in a car with a flurry of strikes. Police track down the car, and because they're worried about the woman's safety, they go right into the house it's parked at. Inside, they find a woman who's clearly been injured. The suspect, Matthew Stairs, takes off to the basement and barricades himself in the laundry room. Police go in after him, and boom, the arrest happens right there. You can just feel how chaotic and dangerous this whole situation was.
Okay, so Mr. Stairs is in handcuffs. You'd think the immediate crisis is over, right? But the officers aren't done yet. They decide to do what's called a visual clearing search of the living room, which was right next to that laundry room. The reason? Well, it was all about safety. They wanted to make sure nobody else was hiding and that there weren't any weapons just lying around.
And this is where the whole case takes a massive turn. During that quick safety scan, sitting right there in plain view, the police spot a clear plastic container and a Ziploc bag. And inside, they see what looks a lot like methamphetamine. And just like that, what started as a domestic assault call has blown up into a major drug bust. The legality of that one little visual search is now on a path straight to the Supreme Court. So this discovery basically kicks off a fundamental legal showdown. The entire drug charge, everything, hangs on one single critical question. Was that search of the living room, done without a warrant, legal in the first place?
This is the million-dollar question, right? We all kind of know police need a warrant to search your home. But does making a lawful arrest inside your home create a special exception? And if it does, how far does it go? Can they search the whole house, just the room they're in? What are the rules when the sanctity of your home slams right up against the duties of the police?
So this case forces us to look at two really powerful competing principles. On one side, you've got the sacred privacy of the home, our shield from the outside world. And on the other, you have the very real need for police to control dangerous situations and protect everyone from hidden threats. The court had this incredible balancing act to perform.
Okay, so the legal concept at the heart of all this is called search incident to arrest. It's a power police have had for a long, long time. If they arrest you on the street, they can search you and the area you can immediately reach. But the big question here was, should that exact same rule, a rule designed for the street, apply inside a home, where our privacy rights are at their absolute peak? Faced with this huge clash, the Supreme Court of Canada didn't just dust off the old rule. Nope. Instead, they decided to create something new, a modified standard designed specifically for searches that happen inside a home. The court basically said, whoa, hold on. A home is a totally different ballgame. The risk of violating someone's privacy is just so much greater than searching a car or a person on the sidewalk. So they decided the old common law rule just wasn't good enough to protect our charter rights. They needed a new test. So what they came up with is all about location, location, location. The court created this two-tiered system. Think of it like two zones. The first zone is the area right within the arrested person's immediate physical control. You know, anything they could lunge for. In that space, the old, more flexible rules apply. But the second zone is the area outside of that immediate control, but still close by, like the living room in this case. And for that zone, the rules get a whole lot stricter. And for a search in that second zone, yeah, the rules get a lot tighter. First, police have to have a reason to suspect there's a safety risk. Second, that suspicion has to be based on objectively discernible facts. We're not talking about just a gut feeling or a hunch. And finally, the search itself has to be tailored to that specific risk. So if they think another person is hiding, they can look behind the sofa. But they can't start going through your desk drawers. The search can't be any more intrusive than it absolutely needs to be.
And this is a big but. The court wasn't living in a fantasy world. They totally acknowledged the reality of policing. This quote from the majority makes it clear they understood that these situations are chaotic and unpredictable. This new reason to suspect standard still gives police some flexibility to deal with that volatility and uncertainty because they have to be ready for anything.
Now, you might think this was a simple decision, but it was anything but. The judges were seriously divided on where to draw this new line, which just goes to show you how tricky this whole balancing act really is. So, the majority landed on that reason to suspect test, but there was a strong group of dissenting judges who argued for a much, much higher bar. They proposed that police should only be allowed to do a safety search if they suspect an imminent threat, like something that's about to happen right now. They argued this was the only way to truly protect the incredible privacy of our homes.
And man, this quote from the dissent really nails their argument. They saw a home as more than just a building. It's a biographical record of our lives, and its sanctity is indispensable. For them, you could only breach that shield under the most urgent and immediate circumstances. So the final vote is where things get really interesting. It wasn't just a simple majority rules situation. You had 5 judges who said the search was lawful and the evidence was good to go. Then you had 3 dissenters who said no way to both. But the deciding vote, the real twist, came from Justice Cote. She actually agreed with the dissenters that the search was unlawful, but she argued the evidence should still be allowed in. Her unique position ended up being the thing that tipped the scales.
And because of that complex split, the final vote to dismiss Mr. Stairs' appeal came down to 6-3. His conviction for drug trafficking, based on the evidence found in that quick, warrantless search, was upheld.
So the case might have been over for Mr. Stairs, but for the rest of us here in Canada, its impact was just getting started. This ruling created a brand new reality for policing and for our privacy rights.
So what does this all mean for you and me? Well, for the first time ever, police have a clear, 2-tiered set of rules for searching a home after an arrest. The new reason to suspect standard gives them stricter guidance than they had before. Our law now officially recognizes that our homes deserve special protection, even when an arrest is being made. And importantly, the decision shines a light on the unique dangers police often face in domestic violence calls, which was a huge factor in the court's thinking.
In the end, the Supreme Court drew a new line in the sand. It's a compromise between the idea of the castle and the need for a clearing search. It gives police some power to protect themselves and others, but it demands a higher justification than ever before. But like any compromise, it leaves us all with a really big question to think about. Did they draw that new line in the right place?